Hello friends, after my video on the rule 30, 15, 30 days to be followed in the event of a check being returned on insufficient funds, I have received many questions seeking clarifications on this subject. Out of all the questions, I find 3 of them very important and I wish to share them with you in this video. The first clarification which the business owners have sought from me is, in case they have issued a check to a payee who is a debtor or to whom they owe money, in case they don't have funds in the bank, can they save themselves from Section 138 Criminal Act in case they give directions to the bank for stop payment? The second question, which is also very relevant and quite similar, is for all those business owners who receive the bank memo mentioning stop payment instead of insufficient funds. They would like to know whether this bank memo can help them file a case under the criminal offense of Section 138. The third question, which is very, very relevant for many channel partners here, is on the blank signed undated checks which are given to various distributors and sellers for buying material on credit. In case those checks are filled by the distributor with his or her own handwriting, the amount, the date, and that check is returned for insufficient funds, will it fall under the Section 138 Criminal Act? All these 3 questions are interlinked. I will rely on various judgments from various high courts of this country and the Supreme Court of India on this subject. These courts are very, very clear. In case a check has been issued, it is settled principle of law that if a drawer of a check has issued it after signing, it is against a consideration, a debt, or a liability. Be it the check is blank, undated, and admittedly it has been signed by the drawer and he admits that he has issued the check, be it it does not have the amount filled in, it does not have the date filled in, it is assumed that it is for a consideration. Now, if the check is returned for insufficient funds, then of course it falls under Section 138. Now, if it is returned for stop payment, this is where the onus of proving before the court lies with the drawer that he did not have any debt or liability existing before the pay. This has to be proved through a positive evidence. I repeat, it cannot be just a verbal denial. The drawer of the check which has returned for stop payment has to firstly prove before the court that there was sufficiency of funds and he has directed his bank not to honor the check because the mentioned amount is not the actual liability or debt existing in his books. I repeat, in your bank on the day the check is hitting, you should have enough funds available to clear the check, which is what I mean to say by sufficiency of funds, so that this check could have been honored in case there was no dispute. To conclude, all these three situations which I have mentioned, they all fall under section 138 of the Negotiable Instrument Act, and you will have to prove before the court that there was no liability existing with the payee of the check. In these uncertain times, I would advise all the business owners to be very careful while issuing checks and while receiving checks from parties, because in both cases we are going to have a long drawn litigation before the court before you receive the payment or before you are charge sheeted by the court. Hope you understood and benefited from my video. Thank you. Goodbye. Stay safe.